Testing, testing. All right. Hey, just give me a quick thumbs up if you can hear my audio. Should I put it a little higher or a little lower? And we'll get this show on the road. Let's see. Test, test, 1, 2, 3. Test, test, 1, 2, 3. There seems to be a little delay. It looks good here. It looks good here. About to start in seconds. Just want to make sure you guys could hear. Can you hear me? It has been a minute since I've done a live. All right, can you hear me? We're about to talk about Slim 400, PnB Rock, Tory Lanez, and Keefe D. I'm gonna do a quick, just a quick test. What's up? What's up, HI? All right, I'm not going to be able to answer any questions in the comments until after we're done. So I'm not ignoring you guys in the comments, but I'm just going to get through the whole episode, and then at the end I'll address some comments. So here we go. Streets and Scholars. Alex Alonso here to bring you another banger. And in this episode, we're going to give you an update on the PnB Rock case that happened here in Los Angeles. I'm going to give you a quick update on Slim 400. And then we'll talk about Tory Lanez sentencing. His sentencing has been finalized. The CDC has published his sentencing, and I'll talk about how much time Tory Lanez is really going to do in prison. And then we're going to talk about the Keefe D case out in Las Vegas, Nevada, for the 1996 homicide of Tupac Shakur. But before we get into that, man, my USC Trojans squeaked out another victory against primetime Deion Sanders' team in Boulder, Colorado. And that game actually looked like it was going to be a blowout. But, man, the final score of that game, I think, was 48. Let me see if I got it here. What was it? 48-41. 48-41. And USC actually dropped a couple of ranking points, and they're now ranked number 9. They were 6, I think they made it up to 5. So they still won it, 48-41. I don't know why they let these guys come back, but it was 21-0 at some point in the game. But fight on, Trojans. All right, so PnB Rock, the brother that was charged in that case back in 2022. Rock, what's brother's name? Freddie Lee Trone. Freddie Lee Trone, age 40, was charged for that homicide in 2022, and he's still in custody. And he's in custody with a $3 million bail. And his son, and his, I believe, wife, but it's not the mother of his son. All three of them were charged. The mother or the stepmother, Lanell Terry, 38 years old, she was charged for accessory after the fact. And there had been some reports that the son already took a deal or the son was already sentenced. And him being a juvenile, I have no information on what happened to the 17-year-old son. But I can tell you that Freddie Lee Trone, the guy that was charged with killing PnB Rock at that Roscoe's Chicken and Waffles, he will be in court. He's still going to court on a pretrial hearing on October 30th, 2023 in Compton Court. So that case is still ongoing. And also Chantrell Trone will be in that court and will be in court on that same date as well. And if you guys remember, Chantrell was released. She was released, but Freddie Lee Trone is still in custody on $3 million bail. They'll both be in court on October 30th. And give me a thumbs up if you want me to go to court and cover this case. The pretrial hearing on October 30th will probably be relatively quick. But if you want me to tap in on that hearing, it's not too far from me. I will definitely pull up on October 30th in Compton Court and see what's going on. Give me a thumbs up if you want me to tap in on that case. I will. And a quick update on Slim 400. Slim 400, aka Vincent Cochran. That was the up-and-coming rapper that was rapping out of YG's camp that was shot and killed in Inglewood back in, this has now been almost 3 years, December 8th, 2021. He was shot and killed, and they arrested Michael Lanell Terry, 33 of LA. And there was also a female accomplice that was arrested in that case, Tamara Lynn Bell of Inglewood. And they were both taken into custody just on June 9th of 2022, about 6 months after. And they're both due in court on November 29th, 2023 for another pretrial hearing. They'll be in Inglewood court. And tap in with me if you want me to jump in on that case as well. Slim 400, those are the two people allegedly involved in his death in Inglewood. And also Inglewood court is right down the street from me as well. So I might tap in on that case and find out what's going on. That brother also has a $3 million bail. Both of them have $3 million bails. And then there's a couple other cases, but I think those are the two most, according to you guys, those are the ones that are I guess have the highest interest. The PnB Rock case and the Slim 400 case. And I'll definitely tap in on those cases. If they go to trial, I will definitely be there. I'm not sure if I'm going to go to every pretrial hearing, but if you guys want me to, I'll pull up on them. And I want to get into two more topics, and I'm going to have a guest here. I got a guest here from San Diego. I got a criminal defense attorney from San Diego that's going to help me talk about the Tory Lanez sentencing and the Keefe D indictment. Let's pull him up right now. Jamahl Kersey. How you doing, man?
All is well. All is well. Thanks so much for having me, bro.
Oh, you online. Can you hear me?
Yes, I can. Can you hear me?
Say that for me one more time.
Yeah, can you hear me?
Oh, man, I'm having a technical difficulty here. Let me just fix my thing here. Let's see here. Give me 1 second.
Yeah.
Try it again.
Yeah, can you hear me?
Give me 1 quick second. Dang, I thought we figured this all out earlier. Okay, we'll just do it like that. All right, so Jamahl Kersey.
Okay.
From San Diego, criminal defense attorney. Tell the people a little bit about what law school you went to and how long you've been practicing.
All right, man. I went to the University of San Diego for law school. I went to SDSU for undergrad, so I'm San Diego through and through. And I'm in my 15th year of practicing law, man. So I've been at it for a minute.
And are you originally from San Diego too?
I am born and raised.
Okay, Southeast?
Yeah, so I was born in Paradise Valley Hospital. We getting specific. Live right over near Valencia Park for a hot minute, and then I lived in Oceanside on the east side for the majority of my youth, and then lived with my dad back in San Diego. So I've been within about a 30-something mile radius my whole life, man.
That's cool. And San Diego, I always consider San Diego our sister city to Los Angeles. I got a lot of partners down there, and it's a beautiful city, but it's also got its other side as well. Over there by Euclid and Imperial. You familiar with that part of town?
Yeah, of course. I mean, I lived nearby there. I do remember going over to the Green Cat Liquor when when we were a youth. I think that's where you're talking about.
The Green Cat Liquor Store.
Yeah, man. So that's right there on that corner you referring to. But no, I mean, you have the postcard, right? The postcard San Diego, and then you got the real San Diego. And so yeah, I'm familiar with both.
Now I noticed you was following the Tory Lanez case, and let's talk a little bit about that. Now the CDC just published his release date, which is going to be September 2029. So I did the math on this, Jamahl. September 2029 roughly comes out to about six years, 9 months from December of 2022 when Judge Harryford remanded him. Now he gets custody, he gets credit for all that county jail time as well.
Right.
And 6 years, 9 months. What do you think of that final time he's going to do for the conviction on the assault and firearm plus the 4-year enhancement?
So obviously he's having to do more time than, than if he were getting 4019 credits, right? If he were getting the 1-for-1 credits, then it might be just, 5 years, right? Half of 10 years. But since he's having to do what will end up being almost 70%, then they're hitting him with having to do a higher percentage, probably based on what count one was, that assault with a semi-automatic firearm. So, CDCR is going to do what they want to do, right? So a lot of times, we'll have sentencing for a client, and they may have a strike prior, which means, if they have a serious felony, they're going to have to do 80% of that time. If it's a violent felony, they have to do 85% of the time versus just doing 50%. But that's what it'll say. That's what the judge will tell you. But then when you get to CDCR, they're going to do what they want to do. And oftentimes they'll give people their 1-for-1 credit, even though they're supposed to do 80% of the time, or even 85% of the time. So in this situation, I mean, if they've already designated that it's going to be, that amount of time, then it is reflective of him not getting, 4019 credits. But it sounds like it might be a little less than him actually having to do 80%.
You're correct. I calculated 66%, which is a weird number. But yeah, it's better than the 85% that some people thought he was going to get. But check this out. If this was the 80s or the 90s, he would have got 6 years for the assault with the firearm. There was no enhancements in the 80s, and he would have did 50% of the 6 years, which means he would have did 3. He would be getting out sometime in 2025 instead of 2029.
Right. Yeah, those enhancements, it's tricky, man. That's why there's so much, pushback on these enhancements, because, not only does it make your exposure a lot higher, but it also results in a lot of unfairness in terms of negotiations, because at the end of the day, the DA, the offer that they make is going to be obviously based on your criminal history, if you have any, the seriousness of the offense, and how strong they feel their case is. And so the stronger they feel their case is, that's going to affect how they negotiate a case. And so they're also able to tap into that enhancement. So if you have, a 10-year enhancement, if they allege a 10-year gun enhancement just for using the gun, right? You don't have to actually have fired it, but just using the gun in connection with any offense, then that's going to make your exposure a lot higher, which is going to make the offer higher. So it can make crimes, that wouldn't be worth 13 years, right? So you might have an offense that might be just worth 3 years, but since you had a gun, now they're able to tack on that 10-year enhancement. And so then your offer might be 5, or, it might be 6 when, it really should be, 12 months or 16 months or what have you. So it can really have a dramatic effect on plea negotiations and how somebody assesses whether they should take a deal or not.
Now, there were reports that he was offered a 4-year deal by the LA District Attorney's Office, and he turned that down. When you're dealing with a client and they're offering you something that is at least half of what you could end up, well, actually, there was no way he's going to end up with 20 years. But let's say that if he's found guilty, he's going to get somewhere between 10 and 13. They're offering 4 years. How do you communicate with your client on whether or not he takes the deal or not?
So, and you're right. Sorry, it looks like my screen is freezing. Do you hear me straight?
I hear you perfectly.
Okay. So, his exposure based on the prosecution's memo, their sentencing memo was 22 years and 8 months, right? And so you always have to let someone know what their max exposure is. They have a right to know, what their max exposure is. But the reality is that's in the absolute worst case scenario, and the absolute worst case scenario almost never happens, right? So you have to be mindful of what that exposure is, but it's not what it is. So you want to give them a realistic idea of what they would be facing, if you do get found guilty, if you were to go to trial. And so, with what that offer was initially, given what he was facing and given, what appears to be the strength of the prosecution's case, that would have been an offer that he should have taken. I mean, I understand that, he has immigration issues, and obviously he is able to get a lot of money here in the United States. And so that was going to factor in, because if he were to sign that deal, if he were to sign something related to, assault with a deadly weapon and have anything more than a year sentence on it, then that's going to be basically signing up for your deportation. So I, in addition to doing criminal defense, I defended deportation cases for over 10 years. And so I'm very intimately familiar with how those laws work. And so, yeah, I mean, it's hard for somebody to stomach with, little to no criminal history, a deal in which you are essentially guaranteeing your deportation. And so it wouldn't matter, I know I think recently got married, but he has a kid here, none of that stuff would matter. So the discretionary factors that can usually help you avoid a deportation, none of that would have mattered. All the activism he does, all the donations he does in the community, having a U.S. citizen child, none of that would have mattered. There's no discretion. He'd have been deported. So I think that mixed with just the sheer arrogance, and let's just call it like it is. I mean, he wasn't moving. He wasn't moving like a dude that was facing assault with a deadly weapon charges. Because while that case was pending was when he got into it with August Alsina, right?
Yep.
I mean, out in Chicago. And so it's like, and this is what baffles me in terms of like the real ones that you're supposed to have in your camp. If you have real ones in your camp, they're supposed to not let you get into things like this. They're supposed to not put the battery in your back when you're out on bail facing assault with deadly weapon charges and you're facing 22 years in prison. Like, again, even though that's not, that's the worst case scenario, that's not going to happen. You want to be, moving around like a saint. You want to be moving around like an altar boy in these streets, not, catching new cases out of town, which, they could have taken him into custody. They exercise his discretion, I think, allowed him to stay out. But that, that's, and I don't know how that resolved that case in Chicago, but he definitely was moving recklessly. And you would like to see, people that's supposed to be in your corner helping you, make right moves and not doing things like that. And also talking sense into him to let him know, like, listen, hey, if you go to trial and you go down on this, which, it appeared that he was going to, then you gotta consider this deal. And, to kind of build on top of that, there was the issue of the email that came out from his former counsel. And I know there's a lot of, conspiracy theories going around, in terms of Rock Nation and what their influence may or may not have been in this situation. But, the reason why I think this is so fascinating is because you would never have an opportunity to see an email from a lawyer to their defense attorney. And we got a chance to see that. We got a chance to see that email from Ms. Holly saying, hey, listen, I don't think that we should, or I wouldn't feel comfortable moving forward with this, with the Kelsey defense, right? Because there's this whole idea of, Kelsey did it and Tory didn't do it. And to see that insight again, this is something that we've never really seen, and you'll probably never see again, because the way these stars essentially had to align is we had to have a celebrity defendant, right? A celebrity facing charges that, brought attention to this, right? Because people shoot at people all the time, but it doesn't make news headlines because you don't have one of the biggest rap stars on the planet. And then, then you have Tory Lanez, who's, a star in his own right. So that's what made this, visible on the national stage. But then on top of that, him having this issue in which they alleged that she had rendered ineffective assistance of counsel. And so when you go after your attorney, in order to put that on, because, the communications between attorney and client are privileged, right? And so, we all have secrets that will, go to the grave with us, right? But in this situation, if you're calling out your attorney, then you have to, on some level, waive that attorney-client privilege so that the court can really assess to see whether or not your attorney rendered ineffective assistance. So that's how this email ended up leaking, where she's saying, "Hey, listen, we want to see." We want to see you submit to a mock cross-examination, and we want to see, I think it was the driver / security submitted to a mock cross-examination. And even if you perform well, even if both of you perform well, which I don't think you will, but if you do, I still wouldn't feel comfortable trying to put this on Kelsey. And so that says so much, because, the defense attorney, our loyalty is to our client, you know what I mean? And so if there's nobody else in the world who's, supposed to have your back and be able to say, hey, this is going to work or this is not, like, listen, this woman had the luxury and benefit of going through all the stuff that we'll never know, that we'll never see, so they went through all the discovery, reviewed it with him. And, you never ask your client, hey, did you do this? You don't do that. And, we could get into why, but that's a whole nother conversation. But you never ask your client that. You go through them with the discovery and you ask for their take on it. You know what I'm saying? So then they're able to give you, what their defense theory is. And it's a collaboration. You're coming up with this defense. So when that would have come out, like, oh, well, we're putting it on Kelsey, then she's going to go through and assess and analyze it. And trust me, I mean, if she felt like that was going to be a viable defense, if we can put it on Kelsey and get the heat off of you, okay, let's do that. And you might, if it's convincing enough, you might even be able to avoid going to trial, right? Because one of the things that, if you go the extra mile with this, and this is what we do at Kersey Law, we prepare all of our cases as if they were going to trial, right? So, and when you do that, that's when you're able to, expose the holes that are going to be in the prosecution's case. Because if you can do that, no DA, DAs want to have as close to 100%, win record as possible. No DA wants to look like a fool and end up definitely not an acquittal, right? Definitely not an acquittal, but they don't want a hung jury either. They don't want a mistrial. They want to get 12 jurors all saying, that the defendant is guilty. And so if you're able to present information to the prosecutor to say, hey, Mr. Prosecutor, hey, Miss Prosecutor, you're not going to be able to prove your case beyond a reasonable doubt for X, Y, and Z reasons. If they're not bullheaded, if they're not stubborn, if they have presence of mind, and if they're not inexperienced, they're going to take that information and say, okay, all right, especially if you have credibility. That's why your reputation as an attorney is so important. You don't want to be cutting corners and be slimy, because then they can't put they can't put any stock in your representations, right? Because it's all based on what you're saying, right? And so if you have a bad reputation, then they're not going to really be able to believe what it is that you're saying. But if I tell a prosecutor, hey, you are not going to be able to prove your case beyond a reasonable doubt for these reasons, then they're going to put stock in that, and they may consider making a new offer that's more reasonable given the circumstances, or in some instances, it can result in a dismissal. So with all that being said, as a backdrop, if we didn't have that happen, then, and I don't know that attorney personally or anything like that, but I'm just saying, at the end of the day, if this were a viable defense, and that's something that they would have been able to use. Instead, it looked like they went in the direction of trying to basically muddy, Meg Thee Stallion's name, attack her credibility and all of that. And that's good for sound bites. You watch that and you can, and I know there's a bunch of opinions on the internet about her lying and the original lies and all that kind of stuff. But at the end of the day, those type of attacks only go so far, right? So you can, because a person can lie 1,000 times about all kinds of different things, and they can be telling the truth about the one thing that is the only issue that matters in the case. And so if you, he said, I'm talking too much. That's what I got brought on here for. I brought it. You just want to look at me. You
guys are listening to a criminal defense attorney, give you his insight.
So at the end of the day, you needed to have somebody be able to directly refute the things that Megan was talking about. If you couldn't do that, then this was the only logical result that was going to end up happening.
Well, Shawn Holly was clearly aware of the statement that Kelsey gave to the prosecutors a few months before trial, and she knew that it was probably going to be a difficult task to blame Kelsey as the shooter. But before we move on to Keefe D, I got 4 more questions on Tory Lanez based on what you said. The first one's about immigration. You're saying that he would be deported regardless. But what's the whole purpose of having the immigration hearing if you're allowed to fight it? And from what I understand, if you have children that are U.S. born and you have a family, that is one possibility of one possible way of fighting deportation. Am I right about that?
Yeah. So he would have a right to to removal proceedings, right? Because that privilege of having a green card and being able to remain in the United States, you have due process rights. Right. So even people who don't have a green card, at the end of the day, they, if you have no status at all, you've been in the United States illegally, you still have due process rights to be able to put your case in front of the court. The question is whether you would have a defense that would allow you to be able to stay in the United States. And so the remedy that he likely would have ended up applying for is called cancellation of removal. And so cancellation of removal is basically a remedy to help you avoid deportation. You have to have been in the United States, at least 5 years, or you have to have been a green card holder for 5 years, been in the United States for at least 7 years, and deserve relief as a matter of discretion by the judge. But the issue is you cannot have an aggravated felony. And so there's a whole list of offenses that are considered an aggravated felony. And under immigration law, those are considered like the worst of the offenses. One of those would be a crime of violence for which you were sentenced to at least a year or more. And so clearly an assault with a deadly weapon would be a crime of violence. Even if the deal in the best case of circumstances would be 4 years, that's clearly in excess of a year. So with that aggravated felony, that would have barred him from being able to request cancellation of removal, which would have meant that he would have had no remedies to be able to, to be able to save himself from deportation. So essentially, he could go through the motions, but there's just no way he would have been able to avoid deportation.
Okay. And then another question that a lot of people ask me is like, even though he shot a firearm and perhaps it was fragments that went into her foot, I know here in Los Angeles, we take gun crime very serious. So even if you shoot a gun into an inhabited building where there's no victims, you're still going to prison. Is it as strict down in San Diego when you just shoot a gun with 0 victims, they're going to prosecute that to the fullest?
Yeah, I'm actually dealing with that issue right now, a dispute as to whether, a client of mine had actually shot into an inhabited dwelling, right? There are people there and there were shots that were fired within the vicinity of a house that was occupied, but he wasn't at all shooting at this house. And yet that's a charge that he's fighting. So yeah, it's definitely consistent. But at the end of the day, with an assault with a firearm or with an assault with a deadly weapon in general, you don't actually have to, make contact with somebody. It can just be based on an act which, is likely to cause great bodily injury. So, he didn't need to actually physically shoot her in order for, for a jury to find him guilty of, an assault with a semi-automatic firearm. And I think that's something, that a lot of people don't understand, and, not through any fault of their own. It's just that the laws are sometimes complex, and what the name of the statute says isn't necessarily what the DA would end up having to prove.
And it doesn't matter that her foot healed within a couple of weeks and she was twerking on the dance floor a month later. That does not take away from the severity of the offense.
Right. I mean, it is a mitigating factor, right? And if I'm the defense attorney, I'm definitely stating that. I'm saying that, because let's just say he blew her whole foot off, right? Then that's certainly going to be an aggravating factor, right? But if she, suffered very little injury, was able, to twerk within, days or weeks from the incident, then that's certainly going to be a mitigating factor that we're going to use as part of, reducing or making the counter offer that's going to be more realistic given the circumstances. But in terms of, whether he was good for an assault with a semi-automatic firearm based on, what the allegations were, then yeah, he would have been.
Now, lastly, a lot of the social media posts became a central part of this case, and the DAs did not hesitate on bringing up things that Tory Lanez posted. He tried to minimize the offense. He tried to taunt Megan Thee Stallion. When you have a client with Instagram, Facebook, Twitter, how do you get that person and convince that person to say, do not post, do not use the internet, do not mention this case at all? Was he getting bad advice, or was he just not listening to his counsel?
It could be a combination of both. Listen, I can only look at what we've all seen, right? And you can look at a person's moves, you can look at, how they move, their demeanor and the like. There was nothing that suggested to me that he would have been taking any advice to just chill, right? And if I'm his legal counsel, which if you're operating at that level, he is a business, right? He's not only an artist, but he himself is a business. And there's a lot of people that are, that he's responsible for. And there's moves that are made to protect a brand and protect that. And you would like to think that, hey, listen, if you're under investigation or you're being charged with something like this, you need to not be making any statements on Instagram. You need to not be going live talking about your case. Why? Because when they say anything you say can and will be used against you in a court of law, I don't know why people think like that's a joke or why people think that's not real. Because listen, now these days, this day and age, right now, I have 40,000 pages of Instagram posts for a client who's, facing some serious charges, and they go through everything. They go to Meta, so Meta is a parent company of Facebook and Instagram, and they get a subpoena and they say, hey, we want all the files. We want all the videos, all the DMs, all the posts, all the comments, and they really get after people. So social media posts can be the subject of a gang enhancement. Social media posts can be the subject of criminal threats charges. There's a lot of different things that they are able to use social media. So definitely the advice would have had to have been like, you just stay off social media. Just let that go. You probably have a team that can do posts for you and promote your music and do all of that. But you personally, you just need to be away from that. And I have to think that either somebody in his camp personally or his legal team definitely would have told him not to do it. And he did it anyway. So, you can only say so much, but people are going to do what they're going to do.
I believe it did hurt his case. The prosecutor used that in his arguments to the court. The judge was fully aware of the things he said, and it can never be a good look when you're making statements about the victim in the case.
Right.
So, all right, let's
that video definitely.
What was that?
With the knife and at the butcher shop and everything that he, yeah.
Oh yeah, the music video. I wasn't even thinking about the music video right now. I was just thinking about some of the posts that he made. He did a few videos. He did some Instagrams. He did some posts about basically saying that Megan didn't get shot, and I just don't think that's to your that goes against your strategy.
Right. Absolutely.
And the strategy should be to say nothing, to post nothing. And if you're an artist, you shouldn't even be creating art like a music video or a song about the case you're about to go on for trial. You know, it's just some of his actions just are outlandish. And at the end of the day, it didn't hurt. But he will be getting released in 2029, December of 2029. He could possibly get some good credit for some courses and classes and programs that he gets himself involved in. You usually get about 2 to 3 weeks credit. So, you know, if he's trying to knock off, 6 months, he's going to have to do a lot of programs. And then he still has his appeal.
Right.
So, we'll see what happens with that. And I'll bring you on for a conversation about a possible appeal issues on another date.
All right.
But,
and since we're talking about all the mistakes, I do hope, because it sounded like in his argument to be released that he cited, or his argument for a lesser sentence, he wanted to go into a rehab program. He said that he suffers from alcoholism and has some mental health issues. And I think, he should get the help that he needs. I hope that he does. I'm not going to be the one that wishes bad on a brother. I definitely want to see us all succeed. And if he's got some demons that he's got to work through, then I hope, sometimes, when you're just moving too fast, you need to have that time, to take a pause. I can't tell you how many mothers and fathers that I've spoken to where they said, hey, I hate to see my baby in jail, but I'm so glad that he's in jail, because otherwise he could be dead right now. You know what I mean? So there's always a silver lining there. And I really sincerely hope he gets the help that he needs, and comes out better on the other side.
Yeah, definitely. I believe that he's going to enroll in some programs at prison that will help him get some time knocked off. But in terms of his music career, and then you're saying the deportation, you need the United States. You need to be in the United States to really, to be that artist, that successful artist that can tour, that could, make the money that you were making before. And I don't see him being able to bounce back from all that. If he's going to get that deportation, he's going to miss most of his 30s when he gets out in 6 years, and then he's going to be deported for whoever knows how long. And I don't know if he can come back as an artist. I know that's probably outside of your expertise, but being that deportation is going to add some more years to the sentence he already has, is there a possible comeback for Tory Lanez as an artist in his 40s?
So I don't think that he comes back to the United States, but I don't think that's necessary in order to, be whatever you deem to be successful. I mean, there are a lot of artists now who were big in the 90s who get crazy money overseas. You know what I'm saying? So there's definitely bags to be gotten in Japan, in Europe, in wherever you want to think. So he doesn't need to be in the United States to get money. And hey, by the time he gets out, I mean, the way that we're moving with, just digital streaming and everything, you do a concert from, you could do a concert from your bedroom, right? We saw what we were able to do with these verses. So, if you get a slick team behind you, there's going to be a way to continue to get to the bag. I think, as long as you're putting out quality music, which he clearly has the capability to do, then you can definitely get to it. Obviously, it'd be beneficial to be in the United States, but he certainly doesn't need to be.
Now, if you're barred from the United States, are there other countries that kind of jump on the bandwagon and say, well, you're not welcomed here either? You mentioned Japan, but are there some countries that will be tough to travel to if you've been banned from the United States?
Now that you say that, I just realized, I mean, Canada's laws are more strict than ours when it comes to immigration. If you have a DUI, you can get into the United States. You can't get into Canada. So that might be problematic for him now that I think about it. So I see somebody put in the comments, hologram Tory. Yeah, hey, you make it do what it do. So yeah, moving throughout the world might be a challenge, but I'm sure there's some countries that'll let him in. He'll find a way to get to it.
All right, man. Let's talk about Keefe D. He was just indicted on one charge of murder 27 years later. I don't think I can recall a case that's 27 years later that doesn't have DNA involved in it. You know, this is this is a non-DNA case, and I want to play a clip first from the press conference of the detective, and then we'll talk about it. So let me play this clip real quick, and then we'll come back to it.
Davis, also known as Keefe D, for the murder of Tupac Shakur. This case has been
Can you hear
reviewed
that?
by our homicide team and homicide detectives for over 2.5 decades. And ultimately, our persistence in this investigation has paid off.
Can
Let me
you hear
walk
that?
you through a timeline of events as we know them right now. Prior to September 7th of 1996, as we all know, Tupac Shakur was an artist who was signed with Death Row Records. And that Death Row Records and its CEO, Marion Suge Knight, were closely affiliated with the Mob Piru criminal street gangs, and that they had an ongoing feud with the Southside Compton Crips. Duane Davis was the leader and shot caller of the Southside Compton Crips. And both of these gangs operated out of the Southern California area of Compton. On the night of September 7th of 1996, Tupac Shakur, along with Suge Knight and members of their entourage, which include members of Mob Piru, came to Vegas to attend the Mike Tyson fight at the MGM Grand Garden Arena. Members of the Southside Compton Crips, which included Duane Davis, along with his nephew Orlando Anderson, were also in attendance at the same event. As both were leaving the fight, members of Death Row Records spotted Orlando Anderson near an elevator bank inside the MGM, and at that time they began to kick and punch him near that elevator bank. I will now show you hotel security footage, as many of you have already seen, related to this incident. And on this incident, you will see Tupac Shakur, who's wearing a shiny satiny shirt, along with Marion Suge Knight, who's a large man in a brown suit, punching and kicking Orlando Anderson. Following this incident, you'll see hotel security intervene, and then they will leave the area of the fight. Little did anyone know that it is this incident right here that would ultimately lead to the retaliatory shooting and death of Tupac Shakur. Following this incident, Tupac and Suge Knight both left the MGM to make their way to a post-fight party, which was to occur at a local nightclub. At the same time, word had spread amongst members of the Southside Compton Crips of what had occurred inside the MGM. And then that's when Duane Davis began to devise a plan to obtain a firearm and retaliate against Suge Knight and Mr. Shakur for what occurred inside the hotel against Mr. Anderson. After Davis obtained a gun, he entered into a white Cadillac along with Terrence Brown, DeAndre Smith, and Orlando Anderson. Based on our investigation, this is where we know they were seated. At some point in time, as they were in the white Cadillac, Mr. Davis took the gun that he had obtained and provided it to the passengers in the rear seat of the vehicle. As they were as they were driving west on Flamingo Road near Koval, they located the black BMW, which was driven by Suge Knight, and in the passenger seat was Tupac Shakur. And as they turned around, they pulled up near the passenger side of that vehicle and immediately began shooting at Mr. Knight and Mr. Shakur. Following that shooting, the white Cadillac fled the area southbound on Koval. And after our officers arrived on scene, Tupac was later transported to the University Medical Center, where he was treated medically and died approximately 6 days later on September 13th. My homicide section handled this investigation from its onset and for a short amount of time. And within a short amount of time, what we knew was that we were working a gang investigation where our victims, our witnesses, and our suspects were all from Southern California and not local to Las Vegas. Within the first few months of the investigation, our detectives knew most of the information I just briefed you on. However, we never had the necessary evidence to bring this case forward and present it for criminal charges.
Okay. All right, that was just the other day. Clark County authorities charged Keefe D 1 count of murder. Jamahl, I want you to break down how is this possible even though Keefe D had a proffer agreement with LA and federal authorities several years ago when he admitted to the shooting.
Man, just first of all, seeing that picture of Tupac is still, after all these years, is just so eerie to see that look on his face. It's still tough to look at all these years later. But to answer that question, this is a different state, right? So we're in Nevada, and I don't think that they would necessarily be bound by by a proffer in California. That's definitely a legal issue to look into. But ultimately, the reason it appears at this point why they didn't pursue on the information that he provided was because it was, a limited non-prosecution agreement. So they would not be able to use his confession against him. But then what ends up happening is if you are making a number of statements independent of that agreement, right? So he's done Vlad TV, all these different, media outlets telling his story and the book, right? So if you're making all these statements independent of that statement that you gave, that's where, they're able to do this. And, it is a little suspect why it's happening this long later. But, detectives can come back and look at files and say, hey, man, I've been seeing this dude giving all these interviews and making statements, and say, hey, man, let's open this thing back up. I mean, and that happens pretty often. I mean, we don't hear about it because, celebrities are not involved, but, detectives will dig up cold cases all the time and see if they can, look at it from a different angle, and try and move forward with it. And so when we saw in July, when they went ahead and executed that search warrant, it was like, okay, man, it's on. And then we hear about, okay, now it's going in front of a grand jury. And then now we hear, obviously, charges proceeding.
Yeah, the investigators in Clark County, Las Vegas, Nevada, said that they reopened this case in 2018. They didn't really say why in 2018, but in 2018, it's when Keefe D gave an interview for BET called Death Row Chronicles. And in that documentary for BET is when he first admits to participating in the homicide outside of that proffer agreement. So even though he's protected by that same admission in the proffer agreement, just because if you repeat it somewhere else, you're not under that protection.
Exactly.
So if we do the timeline on this, 2018, that's the Death Row Chronicles interview for BET. And then the following year in 2019, he publishes his book. And I think that kind of put the nail in the coffin for him. I know you mentioned the Vlad TV interview, but that the Vlad TV interview came after the book.
Right.
The Death Row Chronicles was 2018. Then the book was 2019. And a lot of people ask me, but how can what you write in a book be used against you?
Yeah, that's a good question. I mean, anything you say, anything that you publish, anything that comes out on your behalf can ultimately be used against you. So whether you're sitting down for an interview, whether you're writing letters. Now, if it's a writing, right, in a book or a letter or something like that, then it is going to be a little different from you being on tape saying something, and still, there's going to be some scrutiny in that. But at the end of the day, I mean, obviously, Compton Street Legend was a book, is autobiography. He's talking about these things. So these are words from him. And, obviously all the media that he was doing was in promotion of this book. So there's no ambiguity as to whether, and this wasn't like a joke. He wasn't presenting this as, a parody or anything like that. Like, nah, this was, actual fact. At least that's how he was representing it. And so, yeah, those statements can certainly be used against him. And that's why, they don't even really need the information from the proffer, even though they've been sitting on this information all these years in terms of how this thing went down.
Now, I read the book that Keefe D published, and I was actually asked to write an intro to the book. So they sent me an advanced copy and I read the book. But when he starts writing about the part where they shoot Tupac, he actually, for the first time ever, says that Tupac pulled the gun out first. So I was thinking to myself, is this guy anticipating that perhaps this book can get him indicted, but now he has a self-defense argument to claim? But he had never in 20-something years, he didn't tell Greg Kading that of the LAPD. That was never part of the proffer when he was told to tell all the truth. He never said anything about Tupac having a gun. The first time we hear about it is in this book. What's the chances of him trying to use self-defense? Or, well, we know the chances are 100%, but what's the chances of it even working now that he just wrote in the book, Tupac pulled a gun out? Because if they're going to use the book against him, don't they have to consider everything he wrote in the book?
Well, I mean, even if they didn't want to consider everything, he's going to take the stand, right? Because you can't assert self-defense without taking the stand. So if he were to go to trial, then he would presumably say that hey, you know, they pulled out first and then we did what we did. I think the credibility of such a statement ends up getting attacked if you did not say that in your proffer. And one thing, and I'm sure they say, hey, if you lie about anything, this deal is off the table. And so there's a lot of pressure there, because it's my understanding, there was a lot of weight being moved around and he was facing life based on this, drug case that they had built up against him. And that's what led to this proffer session. So his attorney would have definitely emphasized to him, and the prosecutor and the whatever agents were there would have definitely emphasized to him. And they sit up and they nitpick through every little detail that you give them. So, and they say, hey, they tell you, hey, what you're saying, we're going to investigate it. And if you're lying about any of this stuff, then, it's going to come back to you. And I know that they did actually end up speaking to Orlando Anderson, and then, he obviously got shot and killed. But they were going to do everything that they could to make sure that everything checked out. So if he didn't mention it there, then it's pretty safe to say, and again, that, you're signing off that everything that you're saying is true and correct, to the best of your knowledge. So obviously that's a big thing to leave out in a proffer session if, Tupac or Suge or had pulled out first. So, that's probably not going to be very, very credible. But I mean, if that's your only play, then, you got to do what you can. And maybe somebody might believe, because at the end of the day, the prosecutor would end up having to prove beyond a reasonable doubt that he was not acting in self-defense. So, you never know what a jury's going to do. So, hey, you got to try what you got to try.
Well, this is the 2018 interview that, according to Las Vegas authorities, reopened the case up. I'm gonna play this quick 2-minute clip. This is from the BET Death Row Chronicles.
Kefee D and his entourage get into a white Cadillac. Along with Kefee D, the driver is a guy named Terrence Brown. They call him Bubble Up. Behind the driver is DeAndre Smith. He's in the left rear passenger seat. And Kefee D's nephew, Orlando Anderson, he's sitting behind the right front passenger seat. All Southside Crips.
When our little homie said Death Row guys were going to have a concert at the 662 Club. So we went to the 662 Club.
I ran the door at the 662. I seen Orlando and them when they pulled up in the Cadillac. When I told my homies, Southside's up here. My homies that was at 662, everybody had their guns. We knew it was going to be something. They said about 5 minutes.
Tupac and Suge, they never show up. So we left.
Kefee D and crew go back towards the strip.
Stop and got some liquor. We was gonna party and shit. Got our little drinks.
Meanwhile, Tupac and Suge are driving towards the 662 Club. Behind them, there were some girls screaming, Tupac, Tupac.
We came up Harlem, and shit, here he coming at BMW. All the chicks was like, Tupac, Tupac. And he was like, hey, like a celebrity, like he was in the parade. He wouldn't even been out the window. We would have never seen him. my partner, Buster U. When we pulled up, I was in the front seat. Happened to see my friend, Suge.
Suge looks over, he sees you.
Yeah.
He looks right at you.
Yeah, he was here.
You said the shots came from the back. Big Dre, Orlando. Who shot Tupac?
I keep it for the code of the streets. It just came from the back seat, bro.
All right. Of course, when he gave the proffer, he clearly said that Orlando Anderson was the shooter. Is it possible no witnesses and they get a conviction out of this? It doesn't appear that there's going to be any witnesses from 1996.
Right. And one of the things, you know, to one of the comments, I mean, he definitely there's a way that you could try and wiggle around what you had said in the proffer. Obviously, you know, and actually from what I've seen, and I don't know if it's true or not, he put it on Big Dre in that statement. You know, it could have been, I suppose it could have been Orlando or Big Dre, but either way, in this video, he has said, you know, that it was somebody in the back seat. But he could have said, hey, you know, I wasn't trying to snitch on Pop or, you know, or whoever was over there. You know, so if you're if you're picking and choosing when you want to apply the street code, you know, that could be why you decided, hey, well, I wasn't going to say that, because obviously the shots came from somewhere, right? You can't say they magically emerged from the car and went into, so somebody shot a gun. If you should just say they came from the back, then they came from the back seat. But in terms of, you know, somebody else, whether we're Suge or Pop, pulling out first, you could say, hey man, well, I didn't want to say nothing, you know, I didn't want to snitch, and that's why I didn't mention it. But now here on the stand in front of the jury, I'm telling you the truth, and they pulled out first and we were acting in self-defense. And that just makes it like, who's gonna contradict that? You know, then you got Suge. So it's an interesting it's an interesting set of facts to have to play with, to try and, you know, parse through who would be telling the truth and who's not.
Now, hypothetically, if you was a licensed criminal defense attorney in the state of Nevada and he calls you up for defense, Keefe D, what's the strongest possible strategy that this guy has?
I think, you know, just that, if there's already some sort of mention that he's made, obviously in this book, that they were acting in self-defense, then that's probably going to be the best. And again, it's a little difficult when you have already given a proffer session and you never mentioned it. But again, you know, there are reasons. And listen, I mean, the street code is what led to this whole situation happening, and it's not always logical. In fact, most of the time it's not. Right. And so you could say, hey man, that's why I didn't say it. I was only going to say what I had to say and nothing beyond that. But as I sit here and tell you that, hey, this is what the defense is, we were acting in self-defense. Or, you know, if that's not the case, I mean, at the end of the day, you know, the attorney can't put forth some sort of theory that, you know, isn't viable. You can't knowingly put something that you just know to be blatantly false on, and you would want to sit down with your client and walk through that testimony. And if you're not convinced, just like we were talking before, then you would say, hey, this just is not a viable strategy. And then you might just rely on cross-examining the prosecution's witnesses and the like. But, you know, at the end of the day, I mean, you know, he obviously had indicated that he had gotten the gun from one of his homies out there after he heard about this situation. And this was basically a retaliation. And so, you know, it being that, from what I've seen, I mean, he's been saying, hey man, if I got to go to prison for the rest of my life, then that just is what it is. I haven't seen anything that suggests that he's not just about to, you know, go down on this, but we'll see. I mean, a lot of this has all been about, you know, promoting a book. So being able to get money from this, obviously there's a, you know, if it would just some other dude that they end up smoking in the streets, then it wouldn't matter. But obviously, since it's a legend that they ended up killing, there's a great amount of significance that comes from that. And I think the other part of it is, you know, and a lot of times he you know, in some interviews, it sounds like he shows remorse about this other situation, but in other ones he doesn't. And so, you know, from his eyes, it just seemed like, yo, Pac was just another street dude who made a mistake that got him killed, you know, obviously attacking his family. And that's the way they dealt with this situation. So, you know, with there not being that level of remorse and even kind of making light and making fun of the situation, you know, he's been able to get a lot of money, you know, from book sales, I imagine, and streams and whatever he's getting from that. And then on top of that, just the significance of having had a hand in calling the shots and taking out somebody who, you know, from his perspective, he didn't really respect like that. But it just gave him more significance because he, you know, he had a hand in taking that man out.
I find it ironic that this guy admits to committing this homicide against Tupac Shakur in Vegas and then decides to make Vegas, or technically Henderson, right next to Vegas, his home for the next several years, living right down the street from where he committed this. I don't even know if we say allegedly. He admitted it, right? Is this still allegedly? Legally, is it still allegedly? Or since he admitted it in a proffer, it's not even allegedly anymore?
I mean, it'll still be allegedly until, you know, until he admits, you know, guilt, either by way of some sort of plea agreement that just will not happen, or he goes to trial and he's found guilty. So it'll still be allegedly.
Okay. I anticipate that Clark County is going to add some more charges because there's so many more charges they could hit him with. Felon in possession of a gun, maybe transporting a firearm across state lines, you know, other sorts of assault with a firearm, attempted murder on Suge Knight. He was grazed with a bullet. Why do you think they just came out with just one count during the press conference when you know that there's like 6, 7, 8 counts they could probably hit him with?
Yeah, I found that to be somewhat peculiar, but you know, at the end of the day, they certainly can add those charges. And since they went through it via a grand jury, then they've already put, you know, well, actually, I mean, the grand jury only indicted on the murder count, but they still can, you know, add charges. There certainly could be an attempted murder on Suge. I think he got hit in the head. And he had actually said that Pac joked with him about it, right? He was like, yo, you asking me if I'm all right, you got hit in the head, which just, you know, speaks to Pac's personality. But yeah, they definitely could have hit more charges. I think, you know, conspiracy definitely would have been in there and should be, given the facts. But you know, but the murder charge, that principal count, maybe it's just, you know, sending a message that, hey, you are being indicted, or you have been indicted for murder, and we leave it at that.
Yeah, I think the brother you mentioned that he got the firearm from allegedly is a guy named Von Zip, who is deceased. He died of cancer a few years back, and apparently Von Zip was Sean Combs, P. Diddy's right-hand man at the time. So there's been all this talk that is Keefe D going to bring down the whole house and tell the entire story of not only where he got the gun from, but who he was allegedly committing this hit for. I mean, this sounds like a future soap opera in the works. Yeah,
I mean, there's you know, and you see it floating out on the internet, and I respect the journalism that you do digging into all this stuff. Mad respect on that. But yeah, there's definitely the rumors that have floated around that you know, that they got $1 million you know, to put the hit out on Pop. And so, yeah, I mean, you know, he has nothing to lose at this point. So you never know what's going to happen. I mean, I'm seeing all kinds of things that Diddy needs to be nervous right now, and he might need to be. He might need to be. We'll see.
Now, Suge Knight was a witness to this homicide. He's currently in California state prisons, and he's still got about 10 or 15 years left on his sentence. Is it possible that Nevada authorities try to convince Suge Knight to be a material witness and somehow negotiate that he gets lesser sentence, even though he's in a California prison? Can Nevada and California negotiate together on a prosecution?
Absolutely. I mean, they can work together, and you know, I could see them trying to do that. You know what I mean? And obviously that would end up being a point of cross-examination, right? So they would be able to go after, him, just as you go after any snitch in that situation. You're walking them down all the incentive they have to do whatever they need to do to get out early, right? You're trying to get back to your girl, you're trying to get back to your kids, you want to smell the outside air, so you would do anything that the DA wants you to do in order to get out, right? And so you're going after them. But I say this all the time, there's a lot of times there's nothing more credible than a snitch, because they were right there, whether it's a situation where you observed a crime as a victim, or you doing the dirt right alongside your homie, who more credible than the dude that was right on your side to then tell on you. But yeah, I mean, they could try it. They could do that. I mean, it's one thing, we talk about, staying 10 toes down and sticking to the code. But hey, man, once you've been in prison for a while, or if you're facing that time, hey, man, we see people sing all the time. So I could definitely see that happening. And again, the authorities would have all the incentive in the world to work together to make that happen, and they can.
Yeah, I can imagine if they tell Suge Knight, we'll take 10 years off your sentence if you cooperated with this investigation. I mean, he has a boy that's like 10 years old. He has a wife waiting for him. I know he's trying to get out.
Mm-hmm.
So he might actually agree to cooperate. Who knows? We'll find out. But it seems like they would need someone to be a witness, just to say that he was there. I find it hard to believe that they can convict him on the circumstantial evidence and zero witnesses. It's probably possible. I'm sure if we dig deep, we might find a case like that. But zero witnesses and circumstantial evidence?
Yeah, and you they can't just build a case off of your own words. So so they got to have something else. So you would think that that's a play that they've already probably had in the works, that on some secret stuff that we wouldn't know about. But you have to think that they've already gone after Suge and maybe have lined that up, and that could be in part what's taken a while, right? Him not wanting to do that initially or what have you, and then finally deciding that he would do it. And so I see someone saying Suge ain't no snitch, but hey, man, it's crazy, because you see some. I remember years ago when I was a baby attorney working under another lawyer, and there was a case where there was a bunch of dudes who decided to cooperate and take deals, and I was going with this more senior attorney, and we went in there. And before she could say a word, he was like, I don't get down like this. If you even suggest that that's the direction you're going in, I'm going to take that as a threat and I will move accordingly. And I was like, damn, like I had never seen nobody talk like that. I mean, so that was kind of crazy, but you have people who really are, going to stick to that, and they're not going to snitch. They knew what they signed up for, and that's not how they get down. But a lot of people are going to do that. They realize, hey, I need to be in my kid's life. I need to, I'm trying to get back with my lady. Just being able to live life outside of prison walls is very easy for somebody to end up deciding, hey, yeah, I'll take the stand. It is what it is. I'm loyal to myself and my family.
No doubt, man. Jahmal Kersey, you got a YouTube channel yourself where you talk about the law. Let the people know where they can tap in and find you.
Yes, sir. You can find me on my website is KerseyLawOffice.com. Otherwise, if you search Jahmal Kersey on YouTube, you can find me there. Alex, thanks so much for having me. This was fun. We're gonna have to do it again sometime.
And I want to thank all the listeners out there for tapping in with another fire episode of Streets and Scholars. Now, before you go, do you have time to answer some of these questions? There's so many questions here in the comments. Let me see if I can go through some of them real quick. Let's see. Diddy needs a defamation lawyer. You know what's interesting? Kefee D had already accused Diddy of being the conspirator of the homicide against Pac. Diddy never took any action against Kefee D. If that was such a lie, shouldn't Diddy have taken action then?
Yeah, man, because a defense to defamation, if it's true, then you can't use that. It's only if it's a lie. So if it's true, then you have no defamation case. So if you read between the lines, that might mean something. I can't say for sure. That might mean something.
Yeah, I know if I was in Diddy's position, I would have immediately filed a lawsuit against Keefe D, similar to the way Nicki Minaj filed a lawsuit against a YouTuber, and there was another artist that filed a lawsuit against a YouTuber for defamation.
Cardi B in that Tasha K situation.
Cardi B and Tasha K, and then there was another one of another. There were two YouTubers, Tasha K, and then another one that was a smaller YouTuber got sued for defamation, but no lawsuit from Diddy to Keefe D.
Yeah, I mean, and before you go lawsuit, you definitely want to see if you can resolve that informally, send out a cease and desist letter. But yeah, I mean that not happening, and obviously, Diddy running an empire, billionaire. He definitely has the legal team to make that happen, and has the know-how and everything. So it says a lot that has not happened. So.
Someone here said Keefe D's mouth on these platforms was the DNA. How often does a cold case homicide get solved that's 20, 30 years old that doesn't have DNA? I'm not aware of any.
Yeah, I mean that's generally going to be what links somebody to a situation. But in this situation, I mean, again, the whole thing of anything you say can and will be used against you. I think, at the end of the day, his search for significance, because again, there are different ways that we can be significant in this world. Certainly having a hand in taking out one of the biggest superstars in the world gives you significance. I mean, I've seen, I was in England years ago in like 2012 in Liverpool, and just in this random hood in Liverpool, and saw huge Tupac fans all these years later. I mean, this was a man that was so beloved worldwide. So, having a hand in taking that man out certainly gives you significance. And then again, the monetary gain of it all. He had a big reason to get out and do this. And some people just can't help themselves. You know what I'm saying? Like, you would like to think that, hey, if you were able to get away with this, and I think the limited prosecution agreement also kind of gave him this sort of Superman complex, like I'm untouchable at this point, so I can go out and talk about this, kind of like the OJ thing, the If I Did It book. Like, come on, man, like, yo, you went to trial for murder, you got acquitted, take your ball and go home and just shut up. But these people just continue to play with the fire, and with him especially, giving all these interviews, writing a book. It's his own words that have essentially buried him at this point.
Yeah, but at least with OJ, there was no way that he could ever be prosecuted because of double jeopardy. So he was playing around, but he knew that he was safe. He knew for a fact he was safe to play around like that.
Right. Yeah, but still, it's still, you just would. Yeah, I mean, I get it. Obviously, with double jeopardy, that would insulate him from any further harm. But still, it's just a dangerous game to play.
All right, here's a question. Shouldn't he be charged as an accessory to murder rather than with murder? Murder has no statute of limitations, but I believe accessory to murder does. This should be part of the... Well, I don't know how Nevada state law is, but I remember in California, whether or not you were the driver or the shooter, up until recent years, you were charged equally. Yeah. Now they've kind of changed the laws a little bit to where if you're in the car, you can argue, I didn't know this guy was going to shoot. He shot on his own, therefore I'm not responsible. But years before, the prosecutors didn't care. So I don't know how Nevada is going to treat that. But that's a possible defense. Right, Jahmal?
Yeah, I mean, and to your point, depending on Nevada's law, and that's the thing you have to understand, like every state has its own separate penal code, and we all have different nuances. And I certainly haven't dug into the Nevada revised statutes in order to know that. But it sounds like they would be able to charge him as a principal. They certainly would have the option of charging him as an accessory, but having acquired the gun, right? That's where we're saying there could certainly be a conspiracy, in which, that would be as a principal, right? So if we come to an agreement, 2 or more people coming into an agreement to commit a crime, then, you're essentially charged as a principal. So yeah, I mean, those are all details to be sorted out. If they do end up doing sort of that laundry list to cover all bases, then you might have an accessory to murder charge as well. But in terms of the statute of limitations, that might be a way to get around it. And yeah, murder has no statute of limitations. So they can get you, 10, 20, 30 years later.
But accessory to murder has a statute of limitations, right? Am I right here in California?
That's a good question. I'm not certain. I would actually need to look at that. I don't know.
Okay. Here's a statement from Emmett Jones. Besides BET, you're the first podcast to really talk about it. Then Vlad smelled the story and offered Keefe D money, then just took off. Emmett Jones, you're absolutely right. I was actually going to interview Keefe D back in 2019, but I think he wanted $7,000 or $5,000, and I just refused to pay him. And Vlad was willing to pay him because he has the big platform and he could afford to pay an interviewee $7,000, which I cannot do. And even if I could afford it, I wouldn't pay an interviewee $7,000 regardless. But yeah, you're right, Emmett. I passed on him.
Well, there you go. That's all the more reason, if he's, making $7,000 an hour, it's not too many jobs where he can get $7,000 an hour. So he has all the more reason to,
Well, he ended up giving a almost 3-hour interview that first one. I think it was 2 hours and maybe 40 minutes if you go back and look at it. So yeah, okay. But I think the 2018 interview the 2018 interview is really what is the first time he admitted to the homicide outside of the proffer agreement. So I'm not sure what role the Vlad interview plays in terms of the Clark County investigation, but we definitely know that the BET interview played a role because they cited it saying they opened up their investigation in 2018.
Yeah, I mean, Vlad, his reach is so extensive, just millions of views. I don't know these other platforms, the reach that they have, but when it comes to millions, again, I mean, it's not past, you can't put it past police, detectives, and DAs to get offended by someone's activity. And at a certain point, you can just continue to poke the bear and they get offended, and it's as emotional as it is logical in terms of, hey man, we gotta go after this guy. And so hey, it is what it is.
Now, I was asked about the raid on his house back in July, and one of the things I thought that they were looking for were previous drafts of his book, where maybe he wrote it the way he told it in the proffer, and then his co-author may have said, hey, why don't you add this part? Because we don't know how he ended up getting to the point where he said Tupac has a gun. And when you're writing a book, there's usually draft 1, draft 2, draft 3. And since they took all these computers and all these discs out of his house, I think they're looking for other drafts of his book.
Yeah, certainly. I mean, they took a lot. I mean, a bunch of tablets. It was like 5 computers. They had USB and hard drives and pictures and phones. So, man, I appreciate that. That might be the most endearing compliment I've ever received. But no, so they certainly would have been looking for any of that stuff. I mean, obviously, when you're putting together a book, like you said, you're gonna have all kinds of archives, and he would have had photographs and statements and notes and thoughts, and so you might be looking for something like that. And so yeah, if there is, that's because that's a big significant detail to have. And if you don't have that amongst all your notes, but you have everything that occurred before and after, then that's going to be revealing too.
They want to know, will Suge snitch? I know that Suge is in Donovan prison right now. He's on a PC yard, protective custody. He's not on a general population. And from what I understand, he's trying to make some money and he's trying to get out. So I don't know if he'll snitch or not, but he's on the record saying he doesn't help homicide investigators solve crimes. He did say that many, many years ago. And he did also say if he knew who shot Tupac, he wouldn't say. But that was what, 25 years ago. Now it's 2023. He might sing a different song now.
Yeah, people say a lot of things, but things change.
All right, man. I don't want to hold you up anymore. I really appreciate your time. I got to get you on again. Maybe we could talk about Tory Lanez's possible appeal that will. Oh, let me ask you this last question. How long does it take after conviction that the appellate courts will start to look at your case?
So you got to file your notice, and that's within 60 days. And then after that, I mean, it takes time, you know, going on appeal. There's a, you know, I don't do appellate work, but there is a argument or a standard language that you put in the appeal that they, you know, just look through themselves for anything, you know, any ruling by the judge that was improper, you know, any, you know, prosecutorial misconduct or just anything that would have rendered everything fundamentally unfair. But appeals are generally going to take, you know, it can take a couple years. It's certainly not a quick process. And that was why they ended up, you know, making the argument for bail, because what you don't want to have happen is you've been sitting in custody for a couple years waiting for your appeal. And if you're successful on appeal, then obviously it's not fair that you end up having to spend, you know, 18 months, 2 years in custody awaiting appeal that you were victorious on. But in this situation, again, you know, based on that analysis, flight risk and the danger to the community, he certainly would be a flight risk, you know, given that he's not even a U.S. citizen, you know, and he's facing all that time. And then in terms of a danger to the community, obviously, if you have an offense involving a firearm, discharging a firearm, assault with a deadly weapon, you know, they're going to argue that he's a danger to the community, which they did. And so there just was no possible way that he was going to get out on bail pending his sentencing. It just wasn't going to happen.
Yeah, those appeal bonds are really rare. And you know, it's interesting. Tupac Shakur was out on an appeal bond when he was murdered. Somehow, David Kenner negotiated his appeal bond in the state of New York and got him out on a $1 million. So he still had his case pending when he was shot and killed in Las Vegas.
Yeah. Well, one of the things I know with that charge, I think what ended up sticking was just him basically touching that victim, you know, on her bottom. You know, touching her on the butt is what ended up sticking. I know the major charges in terms of I think forced oral copulation, you know, he wasn't convicted of those. And so I think and that sentence was just crazy heavy-handed. And so I think, you know, probably being able to add those to the argument. I haven't seen the moving papers in that, but you know, the combination of it being an extremely high bail, so 1.4 million, and then, you know, having, you know, those arguments in terms of an excessive sentence probably would have led to that. But yeah, man, that situation, which, you know, obviously Suge was the only one to respond in that situation to get him out, is what generated that sense of duty and loyalty to Suge, and you know, that could have been, you know, the catalyst that set forth a chain of events that unfortunately led to his death.
All right, Jahmal Kersey, I appreciate you tapping in with StreetTV. We definitely gonna have him back on again, and thanks for all your work down there in San Diego, and thanks for representing yourself as a professional. And I understand that comment. I understand why that person said that comment about you. You know, hey, we got to have more grown and mature and intellectual conversations on YouTube, because YouTube is becoming a cesspool in lots of spaces of YouTube. And it's very frustrating because that's not how it started off. And right now it's just becoming a big mess. So I hope you guys appreciated this conversation from two educated men from their respective cities. You know, And we'll be back with another one real soon.
All right, appreciate you.
All right, take care.